Good morning, class. Today we are going to look at another topic, which is intellectual property issues in cyberspace related to trademark and trademark disputes on the internet. And as always, I'm going to start by doing a little bit of foundation on trademarks and giving some explanation on trademarks and the law relating to trademarks. Then the second part of this topic will go on to trademark related issues on the internet. Okay. Now, this particular topic is extremely important because, as you know, every business, has got trademarks, and it is the trademark that is going to actually allow customers to identify a particular business or company. So therefore, trademarks become very, very relevant in the context of every business and their customers or consumers. So what we need to do is first go to the basics, right? Now, if you look at trademarks, it started playing an important role with industrialization. So you can see that it is, one of the things that have actually, given importance after industrialization. And also, it became very important as international trade and globalization has begun to play a prominent role after that. And today we are looking at market-oriented economies. So therefore, definitely in the context of the markets, you can see that businesses need trademarks so that they will be distinctive in terms of a particular product or service that they are offering. Okay, so as you all know, definitely trademarks are very much related to commerce. Okay, and in this particular area, you can see that the growth of trademarks, all right, is related to the growth of this market-oriented economy. Okay, which allows competing manufacturers and traders to provide goods and services of the same category, and also to try to obtain an edge in the market, for a particular goods or a particular area of services. Now, I'd like to play this video. All right, hopefully that this will give you a little bit of an idea on the introduction on trademarks.
I suppose you want to know about trademarks. I don't blame you. It all comes down to them. I'll try and be as brief as I possibly can. I guess it started way back in the mists of time. I mean, a really long time ago. When we were Neanderthals, my name could have been Erg. Look, that's Arg. Arg. In those days, the way to impress someone like Arg was by being a toughie. Arg. Arg. These days, we're a little more sophisticated. It's not so much about the thickness of your skull. What impresses is the intel inside, your intellectual property. Did I show you my pen? Look, it does this.
It's not just the things we drive, the clothes we wear, the food we eat. It's everything else too. If it's for sale, it has a trademark. Oh. When you're doing business in all of the European Union, it's recommended to register a European Union trademark. You register one of these at the EU IPO, and you've got protection through the entire EU, just like that. Filing is easy. Thank you.
You're welcome.
You fill in one form, in one language, with one fee. That's one of everything for the entire EU, and a market of almost 500 million people, and counting.
Did you bring the application form?
No need, George. We can file online.
All right, let's go. Take a right here. Is this going to take long, Anne? Do we really need to register our brand?
Oh, give it to me. Business depends on trademarks. All the investment we put into our brands, all the money we spend on advertising, everything we put into researching new products. It all hangs on our trademark. They don't just protect us against counterfeiting and fraud. A registered trademark defines the value of our company. We can sell them, license them, we can even use them as collateral for our next plan. Registering an EUTM is the way to monetize our intellectual property and protect our investment.
Shouldn't we turn off here?
Where?
Here. Too late.
Why didn't you say before?
Okay, so you can see that the importance of registering trademarks, because basically it gives value to your business. And of course trademarks, just like everything else, every other intellectual property, it is an asset of your company. So it's extremely important that we actually know that. And therefore when we actually come up with a trademark, you have to actually see how it is going to, be distinctive enough so that consumers can actually differentiate between goods and services of the same category in terms of quality, in terms of price, and other characteristics. Okay, so basically your trademark will, be should I say, a symbol or a sign that allows consumers to actually look at the alternatives, okay, when they're talking about a category of similar goods or a category of similar services, right? So, trademarks play a very important role for consumers in terms of, like choosing particular goods or services, and they identify trademarks with quality, also in terms of whether a particular trademark is, in terms of price, very high, whether it's affordable, and other characteristics, right? So other characteristics could be things like reputation, right? Or like sometimes certain brands or prestige, right? So all of these things could be the reasons why consumers actually make certain choices in relation to trademarks. Okay, so what is a trademark? Okay, a trademark is any symbol or sign, right, that individualizes the goods or services of a given enterprise, right? Here, enterprise meaning a given company, yeah, dealing with that particular product or service. And also, it distinguishes them from goods and services of its competitors. Okay, so there are two functions here. So that's why it's very important for you to choose a symbol or sign that is very unique to your business, because it individualizes, uh, meaning it's very unique to your business, And then furthermore, the consumers can actually distinguish your products or services with those of your competitors, right? Now, if you look at Section 3 of the Malaysian Trademarks Act, it defines trademarks as follows. Okay, trademark means a mark used or proposed to be used. All right, proposed to be used maybe because it's something new and you are going to use it in relation to your business. All right, and what's the purpose? The purpose is to indicate a connection, all right, in the course of trade. So it's important that it has to be related to a business, all right, between goods and services and a person having the right, either as a proprietor or a registered user, to use the mark. So that means that particular trademark must be related to the owner of that business, or someone who has the right to use that mark. And the person who has the right to use that mark would be the person who is the official registered user. Okay, now I'll play you another video, and this would again give you an idea on the topic of trademark subject matter.
What are the different types of trademarks? The term trademark describes any of the four types of marks that can be registered with the United States Patent and Trademark Office: trademarks, service marks, certification marks, and collective marks. Trademarks identify products, physical goods, and commodities that are either manufactured, produced, grown, or that exist naturally. A trademark is a word, name, symbol, or device, or combination of these, used to identify and distinguish the source of that product. Examples of trademarks include the Nike swoosh symbol, the arched M for McDonald's, and the bitten apple symbol for Apple Computer. What is a service mark? Service marks are exactly the same in principle as trademarks, except that the words, names, symbols, or devices identify and distinguish the source of a service. Examples of service marks include the sleek silver Greyhound dog on Greyhound buses and UPS's brown shield emblazoned with the bold yellow letters UPS. What is a certification mark? A certification mark is any word, phrase, symbol, or design, or a combination of any of these, owned by one party that certifies the goods and services of another party when they meet certain standards or requirements. A certification mark identifies either the nature of a product or service, for example, that it meets the quality standards needed to receive the Good Housekeeping Seal of Approval, or the origin of products or services, as in the certification mark Washington State given to apples grown in that state. What is a collective mark? Collective marks come in one of two varieties: collective trade and service marks and collective membership marks. A collective trade or service mark is any word, phrase, symbol, or design that is owned by a cooperative, association, collective group, or organization and is used by its members to indicate the source of goods or services. An example of a collective trademark is the Girl Scouts logo seen on their iconic cookies every February. A collective membership mark, by contrast, is used to indicate that a person is a member of some organization, such as a trade union or an association like the Rotary Club, but is not used to identify the source of goods and services.
Okay, so you could see, yeah, the different types of trademarks, right? And again, this is very important, in terms of understanding the various types of trademarks, because our intellectual property law, specifically Trademarks Act, will actually cover each one of these trademarks. Okay, now, so you can see that the whole idea of using trademarks, all right, is actually to allow consumers to distinguish your products and services from those of your competitors. and also to make choices, so that they can choose between products and services of the similar kind, right? And also to determine which they prefer, right? So again, as you can see, when you talk about trademarks, it includes service marks, right? Because not only your businesses can come up with products, it can also come up with services, right? For example, AirAsia, right? When you talk about flights, you think about the travel industry, and you will choose between different airlines, and then you think which airlines gives you the best service at the best price, right? So you think about AirAsia, you think about Firefly, you think about Malindo, all right? So you've got in a particular industry different service marks, right, for each of these companies. So basically, you will try to distinguish, right? And try when you are trying to choose, then you try to distinguish between the different companies offering the same service, right? So basically, the functions is to indicate and distinguish the function for services as trademarks, right? So basically, the function is to make sure that it is individualized, right? So indicates a particular company, and then it distinguishes the function for services as trademarks. Okay, so trademark refers to what cannot be registered as trademarks. All right, so under section 15, it tells you what cannot be registered as trademarks, and these include geographical names. So, for example, you cannot use a particular city, right, to the name of a particular city as your trademark, right? For example, you don't want to use the word Paris because that's not allowed, right? Or words having a direct reference to the character or quality of goods. So say, for example, you want to say, if you're selling nasi lemak, the rice, with all that, anchovies, you don't want to say delicious nasi lemak, for example. So that's like the quality of the goods. So they don't allow you to use that word, all right? Okay, so or something like strong, something, when a certain product, in terms of, if you take that product, you become strong, use the word strong, right? So these are things that, refer to either the character or quality of goods, and such names are not, or words or symbols are not allowed under section 15 of the Trademarks Act. Okay, so you can see forms of marks. Okay, forms of trademarks could be in the form of words, in the form of pictures, could be in the form of letters and numbers, or a combination of words and pictures, combination of words, letters, and numbers. So basically, when you talk about marks, it could consist of just words only, or it could consist of a combination of words and pictures, or letters and numbers, etc. Right? So when you talk about words, it could be the name of an individual, it could be the name of a company, represented in a particular manner, right? Or it could be an invented word. That means there's no such word, but it was invented or created. For example, Fuji, Horlicks, Kodak, right? Or words such as Red Eagle, Dynamo, Follow Me, right? Or some kind of sign or symbol, right? Or an individual's name, a famous individual's name, such as Alain Delon, Christian Dior, or signature. Sometimes you can see some of these perfumes have got signatures, right? So it could be any of these things, or it could be pictures, right? It could be two-dimensional or three-dimensional, or it could be letters and numbers, or like I said, a combination of these. Now, if you look at the functions of trademarks, there are 5 functions, right? And what are they? So first of all, they provide exclusive rights and protections in relation to particular goods or services. So for example, your trademark once you register it, it gives you exclusive rights to use that particular trademark in relation to that particular goods or service your business is dealing with. All right. The second function is, like I said before, it allows consumers to distinguish between different goods or services of the same category. All right. And then third, okay, you also have some form of association with quality. This is especially if the product has been around for a long time, then consumers may relate to a particular product uh, with quality, right? So, for example, if you talk about cars, you'll know that definitely things like, cars like BMW or Volkswagen. I don't know about Volkswagen. Recently, it's had a bad reputation because of something that they did that was unethical. All right, but anyway, normally you will see cars like Mercedes Benz, BMW, Audi. All of these cars are associated with quality, right? Advertising. Another reason use trademarks is so that when you advertise, you can use a particular trademark to promote your goods, right? And then finally, last but not least, it's an asset, all right? It's got economic value, and therefore you can either license it. That means you give others the permission to use it for a particular period of time, or you can actually come up with a franchise. But this is not seen so much in relation to Malaysia. Of course, in Malaysia, we've got franchises, but this licensing is taking off in a way, but not as much as what you see in the Western part of the world. Okay, so you can see the first function is to individualize the product, right? And then, of course, when you individualize it, it indicates its source, all right? And then also to create trust, because normally if a consumer uses your goods, right, and then they are very satisfied with it, then there is also trust created, all right? Um, in relation to that trademark, because people identify a particular good, and say, okay, look, I know this goods that I've bought is reliable, is of quality, and so on. So consumers have a feeling of trust towards that particular product sold or services rendered, right? Okay, so if you look at the origin function of the trademarks, all right, you'll know that it distinguishes the goods and services of a given enterprise. Okay, you know these goods come from this enterprise and not the other enterprise. So the trademark allows you to do that. All right. And so, this will allow customers to choose your product over the product of your competitor. Okay. Now, if you look at the next, function is if you look at what do you call it, legal protection, right? So if you look at the distinguishing function, all right, you'll find that to enable that, the trademarks must be legally protected. All right. Otherwise, competitors could use similar signs and try to take away your customers, because your customers will be confused, thinking that if the product of the trademark is so similar, they may think that it is your product or your service, and they may choose that when in actual fact it's not yours, it's your competitors, right? So this is very important for you to register your trademark, so that then you will have the exclusive right over that trademark, and you will get legal protection if somebody infringes your right. So how can a trademark be protected? Right? So there are two ways normally a trademark is protected. One is through use. So sometimes, like when you go to certain areas, especially like, rural areas, that, a lot of people there, they may not go and register their trademark, but people in that district or village have seen this business in that area for a very long time, and they have used the products or services of that particular business. So this particular business have been using that trademark for a very long time, right? So it's through usage that trademark comes to have some form of protection. And of course, the other is through registration. So you go through the official authority to actually register your trademark. Okay, now, so if you look at predominantly, most trademark protection systems will combine both these elements, which is protection through use and protection through registration. Okay, so full trademark protection is usually through registration. So by registering your trademark, you are guaranteed to have trademark protection. Okay, however, use also plays an important part. Okay, because registration merely confirms that the trademark right has been acquired by use. All right, so that means that you have used it and now you're registering it to sort of like reserve that particular trademark for your business. Okay, so definitely usage is also important because you're using it in relation to your particular product in your business or a particular service of your business, right? And sometimes it can be used as a defense of a registered trademark. So sometimes when people sue you for infringement, then you can actually show that you've been using that particular trademark for a period of time, right? So then if somebody sues you, you can say, hey, wait a minute, I've been using this trademark for a very long time. And you can prove that, right? Okay, now, so how about Malaysia, right? What are the laws in Malaysia relating to trademark? You've got Trademarks Act 2019. That's a very new act. It was just implemented last year. Previously, it was Trademarks Act 1976, which was around for a very long time. But this act is no more because it has been repealed. And then finally, as with every act, there are regulations. Okay, so what is the definition of a trademark? Trademark means any sign capable of being represented graphically, all right, that means through some kind of sign or symbol, which is capable of distinguishing goods or services of one undertaking from those of other undertakings. Undertaking here refers to businesses, right? Now, if you look at this new act, actually it is really something that is been waiting, something that a lot of the lawyers in Malaysia have been waiting for, because it has got lots of new elements in this act. Okay, now the first is, under our new act, there is provision for international trademark registration. All right, as you know, previously when you register a trademark, it's territorial, meaning protection is only available in that territory, okay, or in that country. But now with international trademark registration, right, all the countries who have become a signatory of Madrid Protocol system, which is a protocol for trademarks, international trademarks, all the countries who have become signatories. So once you also sign this, your country also signs this convention, then automatically all the member countries who have signed it will give you and your country also protection for trademarks registered in your country. So the trademarks registered in your country will automatically get protected in these countries as well. Okay, so that's really a plus, right? Plus for businesses, because last time, if you want to actually, go and do business in another country, you have to register it all over again, right? If you go through all the process of, they will search to see whether there are similar marks and so on, and you have to pay filing fees, etc. But now it's different because Malaysia has, signed on to the Madrid Protocol system automatically, and we've got this new act that allows for the the international trademark registration. So can you imagine, the moment you actually register your trademark in Malaysia, your trademark is protected to up to 122 member countries just through one filing. All right. All right. So that is the provisions of the Trademarks Act 2019. Okay. So that means for businesses, there is going to be a tremendous decrease in costs and formality requirements in terms of registering their trademarks, and also in terms of expanding their portfolio around the world. That means, your trademarks are, is applicable around the world, meaning your business can operate in all these different jurisdictions. Okay. Now, the other thing that is very different in the new act is it allows recognition of non-conventional trademarks. Okay, originally, you remember symbols, signs, and so on, right? That's the conventional trademark. Okay, words, pictures, and all that. But now, under the new act, they allow you to register, non-conventional trademarks. And what are these? These include shapes, sounds. Okay, so sound is also now a trademark. Like, for example, when you switch on your handphone, right? If it's Cellcom, there's a certain sound, right? Or color, right? Like, for example, colors have also become a registrable trademark. Colors related to a particular product or service. Scents. So that means the smell, right, of a particular, like say maybe, like a perfume, right? The scent of a perfume. That also has become a possible, thing that can be registered as a trademark. Okay, so you can see that there's an expansion, right, to include trademarks in the context of sign, right? So sign here, if you look at section 2, it includes letter, word, name, signature, numeral here number, right? Device, brand, heading, label, ticket, shape of goods, all their packaging. So like Coca-Cola, if you look at the bottle shape, all right, that's also a trademark. Color, sound, scent, and also hologram, positioning, sequence of motion, or any combination thereof. All right. So all of these things, are taking into account changes in the what do you call it? The market of commerce. Okay. Now, the corollary of this would be the increase of potential trademarks and elements which would not have been accorded protection under the current regime. So previously, these were not given protection, but under the new act, they are given protection, right? So this is one of the positive changes under the new act. The other change that you see as well is what you call multi-class filings. So that means, let's say normally when you have a trademark, it is filed in relation to a particular goods or service, right? So for example, if we talk about Hilton, it's definitely in the context of hotel industry. Okay, so definitely the sign Hilton is always associated with, world-class hotels. But perhaps Hilton may want to expand its trademark to include other classes of goods or services, right? Which is what a lot of businesses are doing. For example, if you take AirAsia, right? It has got other associated filings. All right, so they've got tunes, the hotels, right, and they're also expanding to food, right, and beverages offered in the flight, right? So last time they actually they outsourced the food that is being offered in the flights, but now they've taken it over and they've come up with another class of products offered under the Eurasia's trademark. So you can see this is called multi-class filings. So instead of filing one particular trademark for one particular product, you have got now multi-class filings. That means a particular trademark can be related to different products or different products and services. Okay, so just through single application, your listing of goods or services can belong to several classes of classification to the registrar, right? But just one registration, your trademark is related to multi or multiple classes of goods and services, right? The other thing is in relation to trademark infringement. Right now, the new act is more advantageous to the plaintiff or the trademark owner, to the proprietor or the trademark owner. So that means when an infringement takes place, the new act actually allows trademark owner to easily bring a case, to protect his exclusive rights. So if you look at the new act, the infringing mark, for it to be infringing, right, it is identical. Okay, so the element of infringement is the mark has to be very identical or confusingly similar to the registered trademark. So this is the element that is required, for trademark infringement. You have to show that the infringing mark is so identical to yours or is so confusingly similar to your registered trademark. All right. But the thing is, you have to show that it is in relation to the same goods or services. All right. So, for example, if it is Hilton, if somebody is using the H, it has to be also in relation to hotels, right? Not in relation to shoes, for example, right? So the infringing mark has to be very identical or confusingly similar to goods of the same category or services of the same category. If it is any variation, meaning it's a different category of goods, then there is no infringement, right? So, however, it could be similar goods or services, right? So it's not very strict, it's not so rigid, as long as the use of that mark is in relation to, of course, it's better that it's the same goods, but even if it is similar, it is actually, a case for infringement. Okay. Now, again, the new act expands the scope of potential infringers to include secondary users. Right. So that means last time it's only going to be those who are primary users who are going to be liable for infringement. But now even secondary users can be liable for infringement. All right. So in that context, even by just stocking, all right, a particular product, you can be liable for infringement, even though you are not actually selling the product, you're just stocking it, all right, you can be liable for infringement. Also, a lot of secondary users could be found in the context of the internet, all right. You can see people actually, uh, you know, um, put up your products or services without your permission or use your trademarks, without your permission, or doing linking with your, products or services, right? You are actually a secondary user. Okay, and you can be liable for trademark infringement, right? Now, if you look at the burden of proof, you can see that the new act actually shifts the burden from the plaintiff to the defendant, right? in showing that they are, they're not usually using it in the same product or services, right? The defendant just have to show that he was using that trademark just as a descriptor or something that has nothing to do with the trademark, right? That means it's nothing to do with that particular business, right? So imminent infringement is also an action for imminent infringement is also allowed under the new act. Now, what is an imminent infringement? That means that there is a possibility this person is going to infringe your trademark, right? So that's called imminent infringement. Anytime it can happen. Now, previously, this was only allowed under common law, legal action called passing off. All right. So, if say certain people are coming up with counterfeit products, they have come up with counterfeit or imitation products, and they're going to market that product, and you found out, you can actually bring an action for passing off. That means somebody is trying to pass off a particular product as yours by imitating your product, all right? And your customers may think it's the real thing, but actually it's an imitation. So here, under passing off, previously a common law action, you could actually sue for imminent infringement, right? But now this action is allowed under the new Trademark Act as well. Okay. Now, the other thing is there are new defenses. All right. That means if you are going to sue somebody, they have got new defenses under this act, such as they're using it for non-commercial purpose, or they used your trademark for news reporting. Okay, so that could be a defense. So somebody is using your trademark, you sue them, and they're going to use a defense, right? In the court, they're going to say, hey, wait a minute, I didn't use it for commercial purpose. I didn't use your trademark for similar products or services. I used it for non-commercial purpose, right? Maybe to describe something, or maybe to basically do a commentary on your product, so that means it's a non-commercial purpose. Or for news reporting, right? You're doing an evaluation of the top 10 products in this area. So you're reporting. So when you do that, you use the trademarks to actually say these are the top 10 products. So you were just doing news reporting, all right? And so that's the other change. There are more defenses available for people who are sued, right? And then the other thing is, previously, if you find somebody is actually infringing your trademark, usually when you go to the lawyer to get help, they will actually send a demand letter to the potential infringer, or to the infringer. Okay, so that means the lawyer's office will send a demand letter saying that, okay, look, you better stop using our trademark, or we will bring an action against your company, right? So that's a demand letter, right? So that is no longer a step that's used in infringement actions. Okay, a step prior to infringement action. That means normally you need to send a letter warning them before you can start a court case on that, right? But now that you don't need that anymore. Okay, groundless threats of infringement proceeding, introduction of actions for groundless threats of infringement proceedings. So that means, if you send a letter, all right, but you don't follow up with a case, you're going to be in trouble, because they then can sue you and say you were just threatening them with these letters. So now lawyers very seldom want to send demand letters, right? Now, so if you can see under section 16, it says that the registered trademark shall be a property right. So remember I told you trademarks are property or assets, right? So under section 16, it is indicated that a registered trademark is a property right. And under section 39, subsection 1, it says that the moment you register your trademark, Okay, you have exclusive right towards that trademark for a period of 10 years from the date of registration, right? Normally the date of filing, and then if you're successful, okay, that will be the date of registration, and then it could be renewed for a further period of 10 years. So you can continue renewing your trademark for as long as you want, but the moment you stop renewing, then you will lose your proprietary right or your property right towards that trademark. So it's extremely important you don't let it to fail to register. Okay, so apart from origin and distinguishing function, the trademark also has other functions such as quality of the goods, right? Quality of the function or the guarantee function, right? It also have got advertising function and also economic function, as I've explained earlier, right? If it's got economic function, it usually means that it has become a valuable asset, which now the owner can use to either license that particular trademark or franchise it. Okay. Okay, now, so in order for a trademark to be registerable, it should have one of the following particulars, right? Now, what are they? The name of an individual. Remember earlier we went through this. The signature could be invented word or words, a word, but it doesn't have a direct reference to character or quality, all right? Or doesn't have the ordinary meaning to it, or it doesn't relate to a geographical name or a surname, right? Because if it's a surname, other people may have the same surname, right? Or it should be some form of distinctive mark, right? So a name, signature, or word not described above is not registrable unless it is by evidence shown to be distinctive. So all of these are registrable. If it doesn't belong in this category, it is not registrable unless you can show that it is very distinctive or unique, right? All right, so what is distinctive? So under Section 2 of the Malaysian Trademarks Act 2019, distinctive character means the trademark shall be capable of distinguishing goods or services, right? Which the proprietor of the trademark is or may be connected to in the course of a particular goods or services, right? In the case of which no such connection subsists, or where the trademark is registered or intended to be registered, subject to conditions, amendments, modifications, or limitations in relation to use within the extent of the registration. So that means that there has to be a connection between that particular trademark and a particular goods or services offered by that business, right? All right, so if there is no connection, then there has to be some form of changes made so that the connection will be there. All right. Okay. Now, so that is in relation to the context of distinctiveness. Right. Now, I will stop here. Right. And we will continue in the next class. As you all know, what do you call it? Thursday is actually a Vesak day, so we are off on that day. So I hope all of you are actually continuing with the group project. Now, to monitor the progress, what I will do is I will actually create a forum in our e-learning, and then each group can actually upload the progress they have made in relation to their group project, and then I will give you a date in which you have to submit your group project, right? Okay, thank you. Everyone stay safe, right? Take care.